and warmly welcome for the guest lecture session related to intellectual properties. And we have Kaushalya Wickramanayake here. She's an attorney in law and a legal practitioner in civil litigation. She holds a Master of Laws from University of West of London, United Kingdom, specializing in commercial law, and a Bachelor's of Degree from University of Jaffna. And she conducts lecture for students following LLB, and she's a great resource for us to do a lot of. She has a lot of knowledge related to intellectual properties. So Kaushalya is in a bit of sickness today, but she agreed to continue for a bit of session as much as she can. So, Ms. Kaushalya, so you can continue the rest of the things. I can understand it's a bit hard day for you, but as we discuss, your support is highly appreciated.
Thank you, Dr. Manisha Kaldera. Yes, as you said today, I'm a bit ill. So, but anyway, we will continue with the lecture. So I hope that you all have got the slides. So we will go by that then. If you have any questions, please ask, right? Can you see the slides?
Yeah, we can see the slides.
Okay, right. So here what we are going to discuss today is intellectual property law. So I have divided this intellectual property law into certain parts to understand well. So first of all, we are going to discuss what is intellectual property and what is intellectual property law. That means the law which governs the intellectual property. And under intellectual property, we find law of copyright, related rights, law of patents, trademarks, industrial designs, and geographical indications, right? So we are going to discuss these in detail. So first of all, let me tell you what is intellectual property. What do you mean by intellectual property? So as you see in this world, there is property, right? So you can touch them, you can see them. So like if you see there are lands, right? They are property acquired by people. And there are books, there are those houses and all, those are tangible assets. But here, what do you mean by intellectual property? In Sinhala, we say buddhimaya depala, right? So intellectual property means the property you have acquired through your knowledge, right? So it is intangible, and also it is a creation of mind, right? Those are the creation of minds, and for that creation of mind, you are given a value, right? That means you have acquired a value to a creation of your mind. So your creation of mind is protected through these, from patents, copyrights, trademarks, trade secrets, and etc. Right? These are the main protections which are discussed under intellectual property law. So as engineers, it is very important for you all, like the patents, right? Because you all are going to do more inventions in future, so it's very important to your inventions to be protected, right? And also you all are writing what are these research articles and all. So for that you have the copyright, right? That means your ideas cannot be copied by another person without your permission, right? For that you can sue. If others if others are going to acquire your creations of mind, your intellectual property, then you can sue against them, right? So this is what the intellectual property means, the property you have acquired through knowledge, right? Okay. So intellectual property law means the law which protects the intellectual property. So the main thing in intellectual property law is to balance the rights of the creators. That means intellectual property holders, and also the public interest of the users. Right? So here, if I say, we'll see a research article, right? So you have written a research article and you acquire copyright to that. Copyright is, you don't have to register in Sri Lanka. You're automatically given the copyright for your research article, right? So here, if some other person is copying your article as it is, then you can sue them, right? So that is what the copyright means. Okay, that is what the copyright and intellectual property law means. And also trademark is also like that. You know, these very well-known companies like McDonald's, Apple, etc. As soon as you see their mark, right? You know, the Apple company, the iPhones, etc. As soon as you see that Apple, you know that this is an Apple phone, this is an iPhone, right? If you see the M mark, the yellow color one, as soon as you see that, you can understand, oh, this is McDonald's, right? There are these like delight burgers, etc. You can understand that, you can see that, right? And we are going to the next one, the patents, right? The protection given to the inventions, right? If you say, if you all have invented a car which is run by water, then actually it is an invention and you are given protection for that your invention, right? So you will be the creator, you will be the inventor, and you will be given the protection, right? And designs means the designs you that means the um if we get a car, right, the design of that car is protected, right? And also undisclosed confidential um inform informations are also protected, right? So here we all these intellectual property rights are granted by the Intellectual Property Act number 36 of 2003, right? We are referring it as IP Act. So from this only, all this intellectual property is protected, right? Okay. Now we'll move on to the law of copyright, right? As you know, that protects expressions, right? If I say uh, your research article, right? So for your research article, you use your expressions, and that is a creation of your mind, right? Right. And also you have referred from other articles. You might refer from other articles, etc. But anyway, you are writing your idea also in that article, right? So that is protected, right? So here copyright means it protects expressions, and it will be valid for the copyright is given for the lifetime of the author and also another 70 years, right? And as I said before, you don't need to register it. And these are the intellectual creations which are protected under copyright law, right? And the main requirement is it should be original and it should be an intellectual creation, right? And it should be an expression, right? Original expression, right? You need to express your idea in a unique way. You should not copy it, right? So literally, these are the categories of this copyright um, law, right? So first one is literary works. So under literary works, you get books, pamphlet, articles, computer programs, and other writings, right? So in the computer programs also, there is object code and source code. So we are referring them as literary ones, right? So that's why computer programs are also protected under literary works, right? And oral works such as speeches, lectures, etc. Artistic works like photographs, drawings, works of architecture, and stage works like dramas, musics, etc. Musical works, audiovisual works. So you can go through and understand these are things which are given protection, right? And when talking about this copyright also divided into two parts as economic rights and moral rights, right? Economic rights are um, basically giving you the economic benefits, right? While moral rights are given, actually it is moral, and we will discuss what are moral rights later. So on economic rights, you have the right of reproduction, right? So you will see, you have already written a book, right? So in a book, uh, you can reproduce it, right, by photocopying it, or by printing it, you can reproduce your book, right? That is right. You have already right, you already get from this economic rights, right? And you can translate the book and sell. By that you can get an income and adaptation. That means you can that same thing, adaptation, like uh, converting it to a book into a drama or something like that. Okay. Public distribution means you are making available that particular your product to the public, and you can rent, you can import, you can public display. Public display means also that you can show it to the people, right, in many ways, through social media, through broadcasting, etc, like this, right? So these are the economic rights. So it actually enables the owner to gain financial benefits, right? These are actually connected with money and financial benefits, right? Now let's move on to the moral rights. Moral rights are given to honor the author, right, in order to protect the honor and reputation of the author, right? For that, a right to attribution means, that means he can show his name in the cover page of that particular book, right? That means uh, your name should be displayed in, in the cover page of that particular book which you wrote, right? And also the pseudonymity. That means if you are using a pseudonym, that's mean like you say like that is not your correct name. You are using another name, like short name, etc. So you can use that name also for your publications, right? Right to integrity means if another person derogate your product. That means if another person tear papers, and if that person is going to um, modify it without your consent, then you can go and sue before the court of law, right? So you are just making my copies without my consent. You are using my name without my consent. So those cannot be done, right? If your rights are violated like that, if another person is gaining benefit through your product, through your book, through your research article, then you can sue. You have the copyright for that, by economic rights as well as moral rights. Okay. Then limitations of economic rights, there are some defenses for these economic rights. That means economic rights are basically therefore generate financial benefits. But here, if you are using that means, like for an example, if we say you are conducting a YouTube video, right? YouTube video about a book which is already been uh, written by another person, right? So when you are when you are doing a YouTube video on that particular book, you can criticize that book, right? You can comment on that book. And also, like, you can, news reporting is some other thing. That means in the news, yeah, right, like reporting current events, etc. For that also this can be done. For teaching purposes, scholarship purposes, those are exempted from this economic rights. That means from these things you can't make any financial benefit, right? If it is a YouTube video, we can say for a certain extent that you are getting some benefit, but you are just using it for criticism, right? You criticism or to give a comment, etc. For that, so that in those instances, your economic rights will not be violated. Okay. And fair use is defined under section 11, and these are the criticism, comment, and news reporting comes under fair use. Fair use is something that is fairly using, right? That means sadharana bhavita karanawa. We don't need we that is not for financial purposes, right? So in teaching purposes, we can express fair use as when we are doing assignments, etc. We are just quote we have from where we have taken that particular paragraph or particular idea, particular expression, etc. And private reproduction, teaching purposes, accessibility with people with disabilities, etc. Those are the fair use things uh, uh, we are we are identified under copyright law, right? So copyright law is only that. Copyright law is protecting the expression of the expression of the authors, right? And it should be an original creation of the author, right? Author means the person who write that or do that creation, right, under copyright law. So if I am writing a book, I will be the author, and I will be getting copyright means the economic rights and the moral rights. Okay, now we are going to talk about related rights. Related rights means, I mean, um, related rights comes on it comes as a separate right under intellectual property law, but here it's something different, right? So uh, it is not much important under intellectual property law, but here when we um, uh, create these literary and artistic creations, that means the books, research papers, arts, stage performances, etc., they have to be accessed by the public, right? But most of the time, people or the public means the people around you, right? People or group of people, even you are public, right? So for that, we need an intermediator, right? We need a mediator in order to make these literary and artistic creations, right? These books and other stage performance, etc., to make available to the public. So those those mediators are known as basically they are like this. They are performing artists, producers of sound recordings, and broadcasting organization. We can simply say like that. So broadcasting, for an example, broadcasting organizations are, if we say you the performers are performing a drama, right? So after they perform a drama, that drama should be broadcasted, right? For that purpose, broadcasting organizations are there, right? They are broadcasting that particular drama or stage drama to the public. That means they are the people who are making these literary and artistic creations. That means the works which are getting copyright to the public, right? Okay. Then we are coming to law of patents. So law of patents means patents are given for the given to protect inventions, right? So basically, it is granted by state, and it describes an invention. So it also attracts some of the rights, and also it can the rights of the patent can be exercised by the owner under his authorization for a limited period of time. The rights mostly the time period is 20 years. So invention is an idea of an inventor which permits in practice the solution to a specific problem. Basically, we can say it's a solution to a specific problem, right? Okay. Uh, when talking about patentability for an invention to be patented, that invention should be new, right? And it should involve an inventive step and also industrially applicable. New, that means it should be new, right? It should not have uh, um, um, seen in anywhere else in the world, right? And also it should involve an inventive step. That means that invention, uh, the novel thing that you have already included in that product should not be an obvious to an ordinary person who is skilled in the art, right? For an example, if we say if you have already um, invented a car which is run by water, then if it is very much um, if it is nothing to a person who is an engineer or a mechanical engineer, that is not, that will be not consist with an inventive step, right? And also it should be industrially applicable, right? It should be it should be used in the normal day-to-day life, right? And there are some things which cannot be patented. Um, those are discoveries, scientific theories, etc. And plants, animals, those are there, right? Without, there is no human intervention. So here patents are given only for the creations which are done by the man, right? Okay. So rights of the patent holders are there. You can exploit the patented invention, and also you can transmit the patent, you can license them, etc. Right? Okay. So we are going to talk about law of marks, right? So as I said earlier, there is Apple company, there is McDonald company. So the mark is there for to identify the company differently, right? As soon as you see this M mark, you can identify, that is McDonald's, right? So as soon as you see that Apple mark, you can identify, that is iPhone, right? Like that only the marks are there, right? So trademark is usually a sign, and it should be visible, and it's distinguished goods and services, right? So trademark is, the duration of the trademark is 10 years. So trademark can be um, rejected. So when they are going to be registered, it can be it should be past the absolute grounds and the relative grounds, right? That means if the mark is already descriptive, you won't be allowed to register it, right? And also relative ground means if another person object to your product, then your mark cannot be registered. That means already they are in the domain, right? So you have rights attached with registered marks, such as exclusive rights. And there are limitations of rights, like removal of marks. They are not very much important, right? Rights are, they are like exclusive rights. You can use that sign, assign, transmit, etc. Right? So industrial designs are somewhat similar with the patent. So here the industrial design is given for a design. As I said earlier, the design of the car, right? It can be three-dimensional or two-dimensional form. So it should be novel and not antisocial. That means the design should not be with a design which is scandalous in nature, right? And we are going to discuss about the rights of the registered owner. When discuss about the rights of the registered owner of a design, then you can reproduce it and you can sell it, you can design it, you can uh, assign or transmit by you entering into contracts, etc. Right? Geographical indications means the particular geographical indication is given to a like for an example, if we say Ceylon tea, right? Ceylon tea, that taste is unique, right? It is very much unique to Ceylon tea only. So for that, it is given the protection, right? So if another country is going to sell another tea by naming it as Ceylon tea, then we can sue against that company because they are just using our name to gain profits, right? So that cannot be done because we have already registered geographical indications uh, under this, right? But geographical indications are not much described under the IP Act number 36 of 2003, right? So there is a recent amendment to the Act, that is Act number 8 of 2022. So from that amendment only, this was updated, right? So according to section 160A of this amendment, they have described what is an geographical indication. So it is a protection given to a good which is originating from a country, region, etc. Okay. So Sri Lankan Ceylon tea, Ceylon cinnamon are some of the examples, right? So there are grounds which are not admissible for the geographical indications, like if it is not complied with the definition of the geographical indications, and if it is contrary to the law, morality, or religion, etc., then you can't register it as a geographical indication. And also it is not protected in the original country, etc. In those grounds, this geographical indication can be rejected. So this is an overview of the intellectual property law, which is in Sri Lanka. So if you have any questions, can you ask me? Uh, Sorry if I was fast, because I feel it difficult today. Any questions? So we have reached the end of the presentation, end of the lecture. So if there are any questions, you can ask. Yes, someone has asked about open source licensing. Open source licensing is given for the software-based products, right? So here, uh, it's something which is dealing with source code and object code, you know. So this is actually protected under copyright law. Then okay, open source licensing means it's you're giving or you're you're like licensing your rights to another person through this. But here you're talking about the computer programs which is coming on which is consist with open source source code and object code. So then it is protected under copyright law. Product design, right? Product design is something different from, it is not a software based thing, right? According to my point of view, product design is, it's a three-dimensional thing. So under Sri Lankan law, still it is not possible for a computer program to be um like protect under product designs. It's protected under copyright law only. Elon Musk is there, right? Yes, but that is the law in Sri Lanka is different from theirs, right? So for that we need to uh, refer their laws, right? Okay. Any other questions?
Yes, I think that's all from our end, the audience end. Thank you, Ms. Kaushalya, so for your great support. Though it's really hard day, right? It's really,
That's
really appreciated actually your effort. I know it's double of the speed, but I feel the hardness today while you're doing your presentation. And we have a couple of our lecturers also. We have Professor Udita here, and we have lecturer Mr. Nilang also here. Thanks to all the lecturers and all my other fellows who joined for this session. Professor, anything to be added at the end of the day? Udda madam, are you there? Okay, seems ah, oh sorry. think
And excuse me, there's another question. Are there any international bodies that governs trademarks and licensing and patents? So here, I have to say that there is uh, in Sri Lanka, there is NIPO, right? National Intellectual Property Office. So from that only we are governing, we govern those things. But there is like Paris Convention, etc. According to that, we can get our designs, copy, paid inventions protected under that convention, right? There is no such body thing. But under Paris Convention, the signatories of those countries have the ability to register their inventions and their expressions in those countries also according to their national laws, right?
right. Thanks, Kaushalya. So we can wrap up the session. In like we happy to keep in touch with you for our future work also, and your support will be really appreciated in future too. Uh, so keep in touch with us, and really appreciate your like this great lecture. Thanks a lot again.
And
Thanks
thank you for
everyone.
the opportunity.
Bye. Have a nice day. Then we'll wrap up for this session. Thank you.
Okay, thank you.